European University Institute. My name is Andrew Geddes. I'm the director of the Migration Policy Centre. This is a roundtable on protecting the rights of irregular migrants, policy dilemmas and strategies. It's designed in relation to a project that Martin Ruhs will shortly explain, which is called the Dilemmas Project, looking at key ethical dilemmas in migration policy and politics. So what I will do quickly is introduce the speakers and also just observe that we have an audience here in the room, we have an audience online. The audience online is also invited to participate and can ask questions, but we'll need to do so in the chat box of YouTube. But we would strongly encourage people online to ask questions if they want to. So, as I say, I'll hand over to Martin soon to explain the project that this panel reflects, but I'll just briefly introduce the speakers to you. First of all, I'm pleased to introduce Martin Ruhs, Professor Martin Ruhs, who's Deputy Director or Professor of Migration Studies and Deputy Director of the Migration Policy Centre here at the Institute. Julia Permoser, who's a Senior Research Fellow in the Department of Political Science at the University of Innsbruck, and Michele, LeVoy, who's Director of the Platform for International Cooperation on Undocumented Migrants, who joins us online. I'm very grateful for your patience, Michele. So without further ado, I'm going to hand over to Martin, who's going to explain a bit more about the Dilemmas Project and the discussion we're going to have in this session.
Thank you, Andrew, and thanks to those of you joining us online. As Andrew suggested, we have organized this discussion in the context of a project that we are running on the ethics of migration policy dilemmas, or the Dilemmas Project. And this project is coordinated by Julia, who is also with us today, on my left, Rainer Bauböck, Lukas Schmidt, who is a researcher in the politics department here, and myself. And the basic idea really is to identify specific dilemmas, specific policy dilemmas that are of central relevance to policymakers, stakeholders in the field of migration and refugee protection, broadly defined. And then to submit these dilemmas to systematic theoretical analysis. And so the idea is to bring together people, political theorists, political philosophers who think about the ethics of migration, with social scientists who work on specific empirical issues to discuss the nature of particular dilemmas and also discuss them from a normative perspective. Of course, anybody who kind of says they're talking about dilemmas needs to be clear what exactly do they mean by a dilemma. And part of the discussion today actually also is what is the nature of the dilemma that we are talking about. Now, some dilemmas arguably arise because of political feasibility constraints. So we would like to do X, but because of certain constraints that maybe arise from the policy process, that arise from public attitudes, that arise from political competition, we have to compromise. There are political feasibility constraints. Now, these are important. These can create dilemmas, but what we are primarily interested in this project are ethical dilemmas, hard dilemmas, as we call them, where you have two competing goals that are of some moral value. So in a way, you have a dilemma, and whatever you do, you can never fully resolve the dilemma. You can address it somehow, but in some ways, there will always be at least some moral cost. So those are kinds of situations that we have in mind. And what we've done so far, Julia, Rainer, and I have co-edited, or actually still in the process of co-editing a special issue of the journal Migration Studies, where you have 5 papers that discuss very specific dilemmas. So I'll just briefly go through them to give you an idea of the kinds of dilemmas we have in mind. There's Patty Leonard has written a paper on the tension between restricting labor emigration and protecting migrants abroad. So that's, as many of you will know, many Asian countries sending migrant workers to the Gulf states, particularly female migrant workers to do domestic work, are concerned obviously about the treatment of these workers, and sometimes they impose exit bans, emigration bans. So you have two principles: the right to leave your own country, but then also, of course, the right to be protected in the right to decent conditions. Julia and Itamar Mann have written a very interesting paper which has just been published on the ethical dilemmas that involved in search and rescue at sea. So that's an example of a paper that's not an ethical dilemma, not faced by a policymaker, but by a policy actor in a way, by practitioners, people on the boats trying to rescue people. What dilemmas today face? There's a paper by Sarah Song and Irene Blumrad on the dilemmas involved in legalization programs. So you've got on the one hand the kind of moral claim that migrants make, the idea that people need to be included in the society, in the economy, and on the other hand you have obviously rule of law issues when you think about legalization. Alexander Leinikov and David Owen have written about a paper about protection here or there, the question of you want to protect refugees, the tension between bringing refugees to your country, protecting them here, and giving financial assistance in other countries. And Rainer and I are writing a paper about temporary labor migration programs. So anyway, I don't want to spend too much time on these papers, but if you're interested, I would ask you to take a look at them and also take a look at our website here, because what we're doing is we're organizing debates around each of these dilemmas, where the academic paper is the kickoff paper, and then we have invited various scholars and policy practitioners to respond to see how they perceive these dilemmas and how they would respond to them. We also, and this is the last kind of contextual thing that I'll say, we're also just starting a new section of the journal Comparative Migration Studies, which again will be dedicated to dilemmas in migration policy making. So if there will be a call for papers very soon, if any of you are interested in submitting a paper, that would be very welcome. So why have we organized today's discussion? Well, because we think that there are some important dilemmas also in the field of irregular migration, and specifically when it comes to the protection of the fundamental rights of irregular migrants. So really, one of the motivations and purposes of today's discussion is really to identify what exactly are the policy dilemmas here, what's their nature, and what might be potential policy responses. So I will just make kind of 3 points, and what I say will be based on ongoing research that Claire Fox Ruhs and I have been doing for the Libe Committee of the European Parliament. We've been working on a study on how to reduce protection gaps for irregular migrant workers in Europe, and that study is almost complete and will be coming out by the end of this month. So the 3 points I want to make briefly. The first one is that I think the key challenge when it comes to protecting fundamental rights of migrant workers in particular, but migrant in general, is that there is a fundamental tension between, on the one hand, protecting rights for irregular migrant workers, and on the other hand, migration controls, enforcement of immigration policies, immigration laws. And the way that tension obviously manifests itself very often is that under the EU Charter, of course, irregular migrants in Europe do have access to various rights. But of course, one reason why often irregular migrants are discouraged from coming forward to claim their rights is precisely because even if they're successful in their claim, the most likely subsequent outcome is deportation. So there's a structural link in a way between protecting or making rights meaningful and then removal from the territory. And I think that is the challenge that one needs to think about here. How can you make rights protections meaningful for people whose immigration status makes them liable to deportation? And I think there's 3 elements or 3 kind of aspects of that dilemma. So it's important to ask, what kind of dilemma is this? I think there's an economic and political dimension to it. So in terms of political feasibility, so if you look at public attitudes, obviously, if you look at the research on public attitudes to irregular migrants, if you look at the research and what determines people's views on immigration, we know that irregularity is something that really reduces support for migrants. We also know that control over migration flows is something that people really, really value. So I think irregular migration is a highly politicized issue. So I think there's a clear political and public dimension that sustains this dilemma. There's also a legal aspect to it, which is simply that it is actually quite hard to use the law to help people who, in a way, are outside the law. In some countries, for example, it is very hard to enforce employment rights if there is no legal contract. That varies across some countries. But I think just as a general point, it's very hard to use the law to help people who are outside the law. And coming back to public attitudes, again, actually, if you look at public attitudes in the United States, there's surprisingly little or almost no work on public attitudes to rights for irregular migrants in Europe. But the little work that there is in the US, I have concluded there seems to be much more public support for particular types of legalization exercises rather than for giving rights to irregular migrants, with the one big exception of access to healthcare. So there seems to be more public support for bringing people into legality through some legalization than to giving rights. I think one could raise a question of whether this dilemma also has a moral dimension. And I think that's to be discussed, but I don't see an obvious ethical dilemma in the sense that immigration control, I don't think, is inherently incompatible with protecting fundamental rights. The one other thing I want to say about this is I think this tension is not unique to policies vis-a-vis irregular migrants. I think we face very similar issues when we talk about trafficking and victims of trafficking, where the rescue of victims of trafficking is often associated with deportation, with removal from the territory. So I think there's a structural challenge there. Now, so I don't think that this tension can be fully overcome, actually. But one way in which some people have said this could be addressed is through firewall policies. So firewall policies are basically policies which do not require providers of public services, for example, to report the immigration status of the people who approach them. So if somebody goes to a hospital or goes to a school, a firewall would say that the doctors or the teachers would not be obligated to report the immigration status of the person to immigration enforcement authorities. And some people have suggested that this could also apply to labor inspectorates. Of course, labor inspectorates are enforcement agencies, and they're supposed to monitor and enforce labor rights. And our thinking here is that the firewalls, I think, have been tried and implemented in some countries, but I think they seem to make more sense to be more effective when it comes to the provision of basic public services rather than when it comes to labor rights and employment of migrants. Why is that? When it comes to the provision of public services, I think there is often an understanding that these migrants actually have a right. Irregular migrants under the EU Social Charter have the right to certain public services, to healthcare, to certain education services, even to certain types of social assistance. So, and of course, the providers of these services are not enforcement agencies. I think the situation with labor rights is very different because there, labor rights stem from, in a way, legal employment. So the very act of working is considered to be illegal in the country. So I think the idea that labor inspectorates would turn a blind eye to the fact that the situations they're investigating involve irregular migrant workers seems to me very difficult to see how that might work in practice, not least also because often you want to punish employers. You have employer sanctions. So it seems to me the firewall might work in some settings, but not in other settings, not in other types of settings. My last point is, this is just a suggestion. It seems to me that the way, one way to make these rights meaningful, fundamental rights protections meaningful for irregular migrants is to think about some sort of legal work permit that is given to migrants whose rights have been found to be severely violated. Now, what the EU Employer Sanctions Directive does is it encourages EU member states to let irregular migrants stay on the territory while their cases are being heard. Well, I think that is surely helpful, but I think if a successful claim is made, if if removal from the territory follows, I don't think we can expect too many irregular migrants to come forward. So I think we need something more than that. So something I think like a 2-year work permit, a limited work permit. Obviously, it cannot be unlimited. I think, well, obviously, I argue it cannot be unlimited. A time-limited work permit that gives meaningful employment might be a compromise that addresses some of the issues I think that arise precisely because of this dilemma. So in a way, you wouldn't break completely the link between protection of rights and immigration enforcement, but you would weaken it. And I think you would provide a meaningful way in which actually migrants whose rights have been found to be violated in a severe manner actually do have a chance to work legally for a while. But I think that kind of policy would also need to apply to migrants on temporary work permits who find themselves in a similar situation. Again, that is all I wanted to say. I think the main point is to kind of try to get us thinking about what type of dilemmas arise and what might be our possible normative response and what might be policy strategies for dealing with them. Thank you.
So I'll be very brief. I think what Martin's concluding points there were that hopefully the people have got a sense of what this panel is about, dilemmas and strategies. And so the idea is to put on the table specific ideas for debate and discussion. So obviously it's Martin's project and Julia's project. So now I'm very happy to hand over to Julia, who's going to develop some of these themes. Thanks.
Thank you so much, Andrew. Thank you so much, Martin, and both of you for the invitation to be here today. I'm very happy to speak a little bit more about firewalls and about the ethical or normative dilemmas associated with it. Also, what I'm going to be saying today is based on a publication, a forthcoming publication that I'm editing a special issue together with Rainer Bauberg, another one on sanctuary cities and sanctuary policies across different levels of government in Europe. And what I want to do today is speak a little bit more about firewalls, also in the context of sanctuary cities and in other contexts, and then place firewall policies in relation to regularization programs and see how these two might conflict with one another and raise questions for our discussion about whether there is a conflict here and whether it can be solved or not. So Martin already started speaking about firewall policies, but what are firewall policies and what is the rationale behind them? The aim of firewall policies is to isolate the provision of services from immigration law enforcement. The rationale behind it is that it makes no moral sense to provide rights, to grant legal rights to irregular migrants under conditions that make it virtually impossible for the people to exercise these rights in an effective and meaningful way. So if you give a person a right to emergency health care, but this person is afraid of going to the hospital in the case of an emergency because that would lead to deportation, then that's the same effectively as if this person had no right at all. And the same is true for a number of other areas, right? If you have the right to educate your children, the children have the right to be educated irrespective of regular status, but enrolling your child in school will make your irregular status visible, and that will be communicated to law enforcement authorities, and you might face some kind of penalty or sanctions for that. Then you might not put your child in school, and so on and so forth. If you're a battered woman who is having violence, suffering violence from your partner, but you're afraid to call the police on that because that will lead to deportation, then you're becoming even more vulnerable, and your rights are effectively not existent in a practical way. So the idea is to create this wall that blocks the access to basic rights and services and provided by authorities from immigration law enforcement. And there are three types of firewalls, basically. The first type is what we would call don't ask, don't tell policies. So it creates an information firewall. It means that state officials or service providers are prohibited by law from asking about legal status, from asking for if you have a visa or not, a residence permit or not. When you go to the hospital, when you go to the school, when you try to access that service, the person on the other side of the desk is not allowed to ask about your legal status. And if that information is somehow known, is prohibited from transmitting this information further to immigration law enforcement. The second type of firewall policies is what I call don't let in, a kind of physical firewall. So the idea here is that raids, immigration law enforcement raids, are prohibited from occurring in certain types of spaces, like the hospital, like the school, like the church, or within a certain physical distance from such sensitive locations. And the third type of firewall policies is what I call don't assist or non-cooperation policies. And here, the main example is in the United States, when immigrants who are irregular migrants are in detention for a crime, a regular crime, say stealing some food from the supermarket or I don't know what. That if ICE, the immigration law enforcement authorities ask for cooperation from the local authorities, from the local police to hold this person longer in detention so that the deportation can occur, the police will not cooperate in that way. So these non-detainer policies, they're called, that if there is no legal obligation to hold a person any longer in detention, they will not do so just to facilitate deportation. This is the third kind of firewall policies that exist. Where and how are firewall policies implemented? In the literature, firewall policies have mainly been associated with sanctuary cities, and also in the United States context of the political and mediatic debate, there is a very strong linkage between sanctuary cities and the notion of firewall policies, to the point that most authors really equate sanctuary cities with firewall policies. Sanctuary cities are those and only those that put in place such firewall policies. In that context, firewall policies have been interpreted as part of a federal contest of competence between the local level cities and the federal level national government, and as an act of resistance. So those local administrations that do not agree with the immigration policies, the immigration regime of the national level, use their local level competences to effectively invalidate those policies, let's say, by enacting firewall policies that will make the distinction between having legal status or not having practically irrelevant for all practical purposes for accessing and the city, the services of the city, for living a fulfilled life within the city. So in the US-American context of sanctuary cities, firewall policies are embedded in a much bigger kind of transformative and ideological aim of making the city equally accessible and open to all, and essentially invalidating the distinction between legal and illegal status. They are akin in the way they function to a de facto regularization, and very often coupled with other types of policies, such as issuing local level IDs for irregular migrants, so effectively documenting the undocumented, if you will, for the purposes of the city, or even in some cases granting local voting rights. Now, in Europe, firewall policies also exist, even though there has been much less attention given to it at different levels of government. In the European context, they are spread throughout different countries, and they are adopted sometimes at the regional level, sometimes at the local level, sometimes even at the national level, and are not part of such a kind of politics of resistance but rather much more focused on the limited goal of protecting and making effective the existing basic rights of irregular migrants in some specific context, say, for example, in access to healthcare, emergency healthcare. So it's a policy of, these are policies in the European context, much more of administrative delinkage. Let's just decouple the administration of immigration law enforcement from the administration of health and so on. And it's the rationale for it is protecting the basic rights of immigrants, but also the effectiveness of the public service as in general. So if you have, for example, say a pandemic where you want everybody to be vaccinated, to be tested and so on, but you implement in the access to vaccinations or to tests, people have to show their ID and somehow their legal status, then you're not getting the whole population vaccinated, which is bad for everybody. So there's also a common good, public good rationale to it. And at the international level, we also see important campaigns by PICUM and other civil society organizations to get the notion of firewalls inserted into important declarations, the Global Compact on Migration, for example, or ECRI recommendations by the Council of Europe, or to get firewall provisions into European Union directives such as the Employer Sanctions Directives. Now, how do these firewalls I have been talking about relate to regularization? And what is the dilemma involved between the two? Is there one? Now, as I've mentioned, if applied broadly, the firewalls constitute this wall of separation between immigration law enforcement and access to a very wide range of services potentially. And in that case, it can reach a point, if very broadly implemented, where it effectively eliminates the ability of the state to conduct checks on legal status. So if you cannot conduct raids in a number of places, if you cannot collect information about whether people are legal or illegal, if you cannot transmit this information, if there is no assistance in the conducting deportations, even by the local police and so on, it is as if the distinction between legal and illegal had become suspended. Now, these people, the irregular migrants they are then having access to services and to institutions, of public institutions, but they're still not regularized. For legal purposes, they still have a very vulnerable and precarious status, which means that they are dependent on, for example, the continuation of such policies. There being a government that wants to continue such policies, or otherwise they're vulnerable to the checks and everything again. There might also be restricted in the sense that if they leave the city, the sanctuary city, and go to another city, which is an anti-sanctuary city, which is all for immigration control, they can then be subject to such checks. So it is a vulnerable status nevertheless. And if we implement firewall policies broadly in this way, one could think of it as a kind of toleration of, at least from a legal point of view, a class of people who are clandestine and a sort of acceptance of this state of affairs, right? Don't ask, don't tell, let it be. The alternative to it, of course, is regularization, because it is, of course, normatively a problem to tolerate a kind of legal underclass of members of society. So ideally, you would want to actually regularize people and give them a legal status. But regularizations are never completely unconditional. Regularizations are always based on people fulfilling certain criteria. They have been here for so long, they have a strong moral claim because they have maybe family here, or they have work here, or they have been integrated, or they're broad amnesties, but for a limited period of time. So everybody who applies from now to next year can be regularized, but then we implement strong policies against irregular migration. Why? Because if regularizations would be unconditional and permanent, it would be effectively like having an open borders policy, right? So in order to regularize, you need to check the conditions. Do people fulfill these conditions or not? Or you need to limit it in time, and you need to enforce deportation of those who do not have a strong moral claim to be regularized, those who have just arrived, who do not have family, and so on and so forth. So here we see the tension. Both goals seem morally relevant. Have firewalls that enable people to access the rights that they actually already have legally to make them effective, and yet have the possibility of conducting checks in order to be able to regularize those that have strong moral claims to getting a permanent legal status. But of course, for that, you also need to enforce the deportations. Otherwise, it would be just like an open borders policy. And with this, I want to conclude and leave the question, how can we deal with such a tension?
Thank you, Julia. That was incredibly clear. So I think it's really helped hopefully clarify for the people in the room and online some of the dilemmas. I think you exposed them very, very nicely and very clearly. So now very happy to welcome Michele LeVoy virtually, and hopefully now we can go back into the usual ritual of the online link. And can you hear us? Can you see us? I'm assuming you can hear us and see us. And so very happy to hand over to you, Michele.
Thank you so much. And hopefully you can hear me, although maybe with a little bit of a cold in my nose. So apologies if I have to put it on mute to do some coughing. So thank you very much for the invitation to join the panel. Very good to hear Julia and Martin's inputs. I wanted to complement that by maybe drawing on a couple of key areas that both of you have mentioned, and then also maybe pulling in some insights from how states also see some of these dilemmas based upon our experience of undergoing this International Migration Review Forum process. So Julia mentioned it briefly in her presentation. So in 2018, the UN member states adopted the Global Compact on Migration. And just last week in New York, there was this review process where they looked at what their progress was. And to get there, they also looked at a progress declaration. So I wanted to kind of bring that in as well to also see where some of these dilemmas are coming up. So the first area that I wanted to touch upon, which both of you haven't actually mentioned as much, but I wanted to touch upon it because we've seen a key dilemma here, is on detention of children. So I would say that the dilemma that immigration detention of children. So the dilemma that we've seen played out live, basically in the past 2 months, as states have negotiated 5 versions of this progress declaration, which they just adopted last Friday in New York, was the tension between, or the dilemma between, what exists now as international standards on this issue and what states develop in their own policies. So the standards are such that we have the Convention on the Rights of the Child. There's 196 member states of the UN who've ratified it. The only one that hasn't is the United States. So we basically have almost 100% ratification of that. And in 2017, we had a joint general comment from the Committee on the Rights of the Child and the Migrant Workers Committee that clearly stated that immigration detention of children is always a child rights violation, never in the best interest of the child. So we have basically clear standards from the global level on this issue. And yet we could see as this progress declaration was being negotiated in the past 2 months, that at one point in one of the versions, the language was very clear, very close to the international standards. And now in the final version, it's somewhat acceptable, but it's actually weakening the idea of the best interests of the child. It also says in one of the paragraphs, 57, that no, sorry, not 57, and 32, that children's development is harmed by conditions of detention, but it actually kind of convolutes, or it doesn't really understand what the best interests of the child are, which is basically that children should not be in detention. So there was this whole thing that played out on immigration detention of children. We actually saw it at the end of the day when Greece associated itself with Poland, the US, Algeria, Singapore, Saudi Arabia, and Iran in a joint statement at the end of the whole process, saying that it disagreed with this final language language, which we actually find even weaker than it could have been, around child detention, saying that child detention is required in some cases to determine status. So on the one hand, we find that we have the global standards. The European Parliament has on 4 times since 2018 called on EU member states to end detention of children. There was a report that the Quakers did in 2018 that found that Ireland, as one EU member state, doesn't detain children for immigration purposes at all. There's 8 EU member states that don't detain unaccompanied children. And we also see that there's a lot of community-based solutions that are being developed. So on this issue, I would say the dilemma is really now between the international standards and the fact that UN member states have committed in the Global Compact to want to work towards ending detention of children. Germany actually has made a formal pledge that they will work to do so. They just did that last week. So that's kind of the tension, is between the standards now and how we get this working on the EU level, where we still have the returns directive, which is currently being negotiated, where it does currently still allow by law EU member states to detain children, but with the renegotiation, there might be a possibility that that could be opened. The second point is on regularization, and this has been brought up by both Julie and Martin. I would say that one of the issues that we found on regularization is there's sometimes been a tendency at the EU level for the European Commission to say that the EU does not regulate regularization, excuse me. We actually did a report as PICUM called Insecure Justice a couple of years ago, where we found several EU directives that do foresee, for example, in the area of trafficking, or in other thematic areas, that there could be residence permits that might be issued, kind of along the lines of what Martin was talking about, people who are severely exploited or in other situations. But in a sense, then EU legislation does foresee some form of regularization, although in reality, indeed, the majority of regularizations of programs are done by member states. But what is interesting to see on the global level is that there's a history in the EU, especially of having regularization programs. The major project called Regine that ICMPD led, and I think it was 2008 that they released this study, or a little bit after that. They found that at the time when they were looking over about a 10-year period prior to the project being closed, that the majority of EU member states had done some form of regularization. And we've seen just now in the past recent years, Ireland is actually finishing its regularization program by the end of July. Spain in October of last year passed a law that simplifies procedures for children who have aged out and who would be now between the age of 18 to 23. Portugal, Italy, they've also launched regularization programs during the pandemic. And also the European Commission's European Migration Network conducted a survey at the end of 2018, where they looked at 24 EU member states, the UK and Norway, and they found that 60 different national protection procedures were in place. So basically types of regularization for humanitarian reasons, exceptional circumstances, medical grounds, due to children, having the best interests of the child, non-refoulement, climate change, etc. So it's very much an issue. So I think one of the tensions is actually the visibility of existing policies and procedures that EU member states have carried out for a good 40 years at least. The third area that I wanted to basically highlight, the third and fourth, are access to services and access to justice. And here I would say that one of the tensions, kind of building on what others in the panel have already mentioned, one of the tensions is actually for policymakers, ensuring that their policies on migration and migration control don't override other key policy objectives in policy areas. So here on access to services, it's ensuring that the population can have the highest attainable level of physical and mental health, as the global level actually foresees in the on the global level. It was very interesting to note that the International Committee on Economic, Social, and Cultural Rights from the UN outlined in the year 2000 in General Comment 14 on the right to health, that it actually extends to migrants regardless of status. And this committee actually further elaborated more recently on this in 2017. So we have, in a sense, the global level standards. We also have what's very interesting in the European case, like if we look at different regions of the world, we have 3 EU member states who each have laws that almost date to 30 years ago. So Belgium has a law from 1996, Italy from 1998, France from 1999 on access to healthcare for undocumented migrants. Sweden's law is from 2013. Germany last December in its coalition agreement said it would abolish the requirement to report undocumented to immigration authorities. And then we also saw some practices in COVID. So Norway has a communicable diseases law. And in 2021, the Norwegian Directorate of Health published guidance on COVID-19 care for undocumented migrants. And it addressed a letter to all local and regional authorities, healthcare services, making sure that they would make sure that COVID tests and treatment were available for undocumented migrants in Norway. So we have kind of a whole repertoire of law and practice in Europe on this. We also have the City Initiative on Irregular Migrants that the University of Oxford Compass program coordinates, where there's guidance from municipalities on how to administer healthcare to undocumented. So I think one of the dilemmas is indeed how to ensure that immigration control is not predominant, that access to healthcare, which is basically the reason why most of those laws were passed, is because the health professionals or the civil society or the health arguments, in a sense, outweighed the immigration control ones. How do we ensure that these priorities continue, but how to also ensure, rightly so, that people can access this in practice? So how to make sure that there are firewalls. And this brings me to access to justice. This one is very interesting because of the EU level competence on this. So we have on March 8th this year, on International Women's Day, the European Commission released proposed legislation on gender-based violence. And so one of the proposals is that undocumented women who've experienced gender-based violence could safely report to the police, to access services in the first instance of reporting. So this is obviously very promising. It builds on the Victims of Crime Directive that exists on the EU level, for which there is also a Victims of Crime strategy from June of 2020. And in that strategy, it recognizes that undocumented migrants, because they have a regular status, are particularly vulnerable if they've experienced crime, and that they should be able to access services and justice in a non-discriminatory way. So there's definitely moves, I would say, from the EU level, from DG Justice, to recognize this particular vulnerability, and that the procedures and things in place are basically not really addressing them. But this brings me to the last point, and then I'll finish, which is labor rights. And as Martin said, this is a little bit trickier because of the issue of undocumented migrants and the right to work. Here I wanted to mention that the FRA, the Fundamental Rights Agency, published some research last year, I think it was, saying that there were some major gaps in how the EU Employers Sanctions Directive was being implemented. Yeah, it was 2021 when they published this, because they were saying it was nearly 10 years since it came into force in 2011. And then shortly afterwards, in September of last year, the Commission released its own report on the Employers Sanctions Directive. And in that report on 29th of September, it said that undocumented workers are deterred from filing complaints due to the risks of immigration enforcement during inspections. And it also acknowledges that calls for firewalls would guarantee undocumented migrants who might be detected during inspections would not be referred to immigration authorities for return procedure. So it actually, the Commission recognizes this blockage, and it also calls on EU member states to establish safe reporting practices. The challenge is actually now going forward how to implement this in practice. There's been recommendations from the International Labour Organization body on labor inspectors to separate immigration enforcement from labor inspection. There's ongoing research that PICOM and others are doing that shows what is the challenge on the ground. PICOM actually did a report called A Worker is a Worker, where we found that while the labor inspector issue is still problematic, the courts, the civil courts and the labor tribunals seem somewhat more promising. We looked at 15 EU member states and we found that in 13 of them, most of these bodies, the courts and the labor tribunals, would or consider undocumented workers' claims equally to other workers. So there definitely is hope there. But it's just more challenging when labor inspectors are required in certain countries to then work with the police when they're doing on-site inspections. So I definitely might leave it at that. I've probably taken too much time as it is, but to just say that there are a lot of setbacks on some of these issues as we've seen them. But there's also within the European regional area, a lot of evidence, a lot of research and a lot of evidence of law and practice. And so what we do recommend going forward is in order to have firewalls, to look at regularization programs, is to examine this and that for civil society, researchers and others to work together to find what the adequate solutions are. So I'll leave it at that for the moment. Thank you.
Thank you, Michele. So now what we're going to do is open up for discussion in the room here and also for anybody online who'd like to contribute by putting their questions into the chat box on YouTube. So do we have anybody who'd like to start? I see two hands immediately. So Lorenzo first.
Hi, thanks for this excellent panel. My question is, so I think all of the dilemmas that you have presented are from the perspective of the state or the public authority. And I wanted to add one more dilemma from the perspective of civil society organizations. For them, sometimes it's important to provide rights to irregular migrants, such as healthcare or education, or information on how to navigate the landscape where irregular migrants live. But the dilemma is they don't want to substitute the public authority and take the responsibility away and keep the state accountable and responsible for providing those rights. So I think that's a very tangible dilemma for many civil society organizations that are active in this field. Thanks.
So thank you so much. It was very informative. So I conducted my fieldwork in Barcelona and I talked with over 30 undocumented migrants. And based on this fieldwork, I have two questions for Julia and two questions for Martin. So the first question for Julia is so in Barcelona, police stop mostly the migrants from Africa in the street. And so they do ask their documents, but they do let them go. So how would you frame this practice in terms of firewall policies? Also, the second question is, can we talk about racialization of the firewall policies? Because none of the migrants from Latin America told me that they were stopped by the police, but all migrants from Africa, they were stopped by the police several times. And my questions for Martin, they're mostly about the ethical part. So some of the interviewees told me that they occasionally work for the municipality of Barcelona without a contract. So do you think if there's a dilemma here in terms of solidarity versus exploitation? And the second one, as a researcher, what's my responsibility to unravel the strategies of migrants to avoid police? So to what extent should I talk about these strategies to avoid police in my paper? Thank you.
Could I just add a quick question for Martin as well, finish the first round, so abusing the power of the chair there. but because I like the proposal you've come up with, so I really found it really interesting. But I was wondering to what extent, because you say if people have been who've had their rights abused in a severe manner would be then entitled to some kind of meaningful employment. And I was wondering also, it's almost like this almost exceptional behaviour. So you've been severely abused, or maybe I've seen other countries where you've rescued a small child from a burning building, or you win a medal or something like that. It's this kind of the exceptionality of the behaviour of a treatment that generates entitlement. And I was wondering how that relates to the kind of ethical and moral framework that you've established, this kind of almost exceptionality of the experience. Thanks. So we'll go to a second round in a minute because there's lots of people now, everybody's getting their hands up, so I'll have to try and work that out in a minute. So we'll do the first round first. Start with you, Martin.
Well, thank you. Yeah, thank you for those comments and questions. I'll go in reverse order. Yes, I mean, there are many challenges, obviously, with this idea of providing some sort of work permit for people who've had their fundamental rights violated. I mean, the one challenge is obviously you have to draw the line somewhere in defining the degree of rights violations. So that is one kind of practical challenge. And then I suppose normatively you could think about it in different ways. As I said before, I mean, I don't think you need something like this to encourage people to come forward. I don't think it's enough to just let people stay and say you're protected while your case is being heard, because people are working and they have financial, economic incentives, and if deportation follows, I don't think that they will come forward. Now, the exceptionality, one way of looking about it, one way of thinking about this normatively is that, I mean, perhaps there's an element of state failure in preventing instances of extreme abuse and of extreme violence. So whatever the state's policies are, but if the state fails in preventing extreme forms of or severe forms of violation of rights, that generates, I would argue, actually some sort of moral duty to compensate people. So the work permit would have an element of compensation for harm done that, while some people will say, well, it's nothing to do with the state because it's the employer and the migrant who made the initial decision to migrate. But I think you could argue there's some state responsibility in ensuring minimum conditions for all workers in the country. Now, I think Lorenzo's point, I think, is a very good one about the dilemma of wanting to help people, but that not wanting to replace kind of what are state functions and becoming implicated in a whole system then that relies. I think actually there are parallels to the paper that Julia and Itema, maybe Julia can respond to. There are parallels to this search and rescue situation. I think the dilemmas that people face there. And on the other two, maybe just briefly respond to the researchers. I mean, that's also an ethical question for researchers, I think, and one that comes up very frequently, of course, when we evaluate a research project from an ethical perspective. To what extent is there, to what extent should individuals, citizens, but also researchers provide assistance to migrants? So, I mean, I don't have I have a personal view on this, which is that I mean, if the violations are so severe, I think there is clearly, I would say there is a moral imperative to help, but I think it is a very tricky issue in terms of, especially when it comes to research ethics as well. So it's not an answer, but I think it's a good question. Thank you.
Thanks. And before I hand over to Julia, we've got a question which is actually for Michele. And I'm reading on my phone. I've only got a little bit of charge left, which is why I'm going to ask it now. So it's coming from Raffaele Bazzuli, so online. So thanks very much for this question. And the question is, well, PICOM has warned about the risks related to the use of digital technologies by public authorities, and specifically the EU Interoperability Initiative will facilitate the retrieving of information on immigration status when a migrant accesses public services, making firewalls potentially obsolete. However, member states seem to be lagging behind with the implementation of these digital practices on the ground. And Raffaele asks, what's your provision for the near future? I think in relation to that. So I will first go to Julia, then to Michele, and I'll find a charger. Thanks.
Okay. So yes, thank you so much. Very interesting questions. Let me also pick up on what Lorenzo said. I think this is a general dilemma or tension of humanitarian work in a way, or from many civil society organizations who are in the situation of stepping in and providing services that are just not provided or not adequately provided by the state. And this is something that, as Martin mentioned, was one of the dilemmas or the ethical tensions that, for example, those people engaging in search and rescue in the Mediterranean that Itamar and I have interviewed mentioned very prominently. They said, okay, we are here because the state fails to do its duty, and because there are no state-led search and rescue operations, which is actually what should be the ideal state of affairs, then we have to step in and conduct these search and rescue operations. But to which extent are we, in doing so, helping the situation, helping the states to save face, or they don't feel compelled to do it anymore because somebody else is doing it. And they can blame the rescuers for all sorts of things, cooperating with smugglers and so on and so forth, while at the same time not having to engage in actual search and rescue operations because they know that at least something is being done. So this kind of complicity and at the same time playing into a manipulative sort of narrative was one of the tensions that came up and relates to what you said, I think. Yes, so what you mentioned, Grute, about asking for documents but letting people go and the racialization of firewalls, I think that's very, very interesting in terms of analyzing the actual application of these measures, right? So I have been talking about it at a sort of more abstract level, but of course it all depends on how things are then actually implemented. And you can not have firewalls on the books, and nevertheless people have access to services if the obligation or the possibility of transferring information to immigration law enforcement is simply not pursued, right? So there's a way in which also street level bureaucrats can effectively implement some kind of firewall policy. It could be at the level of each institution, hospital or school. You can have a divergence of policies, but this makes room for sort of arbitrary treatment, right? So ones will do this way, the others will do that way. So it all depends in the end on to which extent this is properly applied and effectively applied in a non-discriminatory fashion. So we need researchers like you to find that out for us, I guess. And that's it.
Thanks, Julia. So over to you, Michele.
Yeah, I think also just to pick up briefly on the firewall, I think it's interesting, as Julia has just said, a lot of these countries actually don't have formal policies on the firewall. It's just practice. Like I mentioned, all these 3 member states that have laws that have basically existed for almost 30 years, and they don't have an accompanying document that indicates in clear language what their health professionals should or shouldn't do concerning immigration authorities. So so you could say like these firewalls in a sense are there, but I actually think that the colleague, I think it was the colleague from Barcelona who asked the question about the racialized impact of this. This is actually something that's extremely interesting, and this leads also to the answer to the digital technology part, because the EU now has the anti-racism action plan, and there are mentions in that, and I think it's from last year, June, if I remember correctly. So there's mentions in there about migration and migrants' rights, but it's very unclear at the EU level how the anti-racism angle is being properly implemented within migration policy. like to really give it substance. And here I can also just say, once again, this progress declaration that I referred to, there were 5 versions of it from March until April when the final one was included. The first version was released 3 weeks after the Ukraine invasion by Russia. The Ukraine invasion prompted all these third country nationals who were fleeing Ukraine, who were from Africa and Asia, to try to get into the EU and to be stopped because they looked non-Ukrainian, they were black, they were brown, but basically they were racialized. So Poland and other EU member states detained many of them, didn't want to let them go further. So there we saw kind of live a whole instance of what anti-racism and migration policies was about. And the EU and the UN was developing that progress declaration. And in that 0 draft that came out 3 weeks after all of that happened, there wasn't even a mention of the word racism. So it was only when the Special Rapporteur on Racism and others kind of highlighted, okay, we have this situation now unfolding now in Ukraine, in addition to all these decades and centuries, basically, of discrimination of third country nationals. Shouldn't we have some more focus on racism? And now in this progress declaration, there's a mention about systemic racism, but this is actually at the heart of a lot of it, is this lack of in-depth perspective of racism within migration policies. And this is also kind of what's at one of the key issues that we're also looking at with the interoperability. So the issue of, as Raffaele mentions, is that these databases, some of them are existing, some of them are new. So some of the new ones, some of them are a little bit delayed, but they all kind of come into play when immigration, basically when law enforcement could suspect someone might be undocumented, and so would plug their name into one of these databases that are then all connected. Now, who suspects someone might be undocumented? Why would they suspect someone's undocumented? Is there any racial element here? I'm asking you because I think we've just heard with the Latin Americans and the Africans that some are searched and some are not with police profiling. So I think the issue with the databases and the interoperability also is that the whole racial element has to be looked at with more scrutiny. We're also looking at the Artificial Intelligence Act. This is now also proposed legislation on the EU level. Migration currently is seen as high risk, but also potentially exempt from the act. So we are working with digital rights partners and others in the privacy space to kind of unpack these issues and also see what it means for people who are undocumented. But we also see in the labor context that this will be an increasing push is to have potential databases accessible on the national level to labor inspectors. And this will also be a challenge then rightly so on the firewall. The firewall is no longer just going physically to the services or going physically to the police, but it's also the firewall in these databases. And how do we ensure that there's this separation? I think it's on mute. Sorry, I can't hear.
Oh, yeah, sorry. So the first question is from Sophia Kagan. I forgot to switch on the microphone.
Great, thank you so much. I have a question for Julia and perhaps to others. You mentioned that sort of regularization is sort of the ideal because firewalls continue sort of that precarious status outside of certain contexts. And that, you know, where migrant workers are eligible for regularization, they would choose to do so. And I just wanted to contest that in the context of rigid migration systems. I come from the Arab states where, in fact, many migrant workers choose to remain irregular even during regularization campaigns because it provides them more freedom than what is allowed within existing migration systems. To give an example, domestic workers have to be live-in workers under the formal system, but being irregular allows them to freelance between multiple households, determine their wages, so to overcome the restrictions of the kafala system. Similarly, sort of other workers who are on employer-tied visas, tied to one employer, might choose irregularity as a way actually to be able to command higher wages and better working conditions. And it's interesting that in the Arab Arab states and in the GCC in particular, we see a regularization really as a way of avoiding structural changes to the migration system. That, you know, when a certain number of irregular workers accumulates, there's a regularization or a deportation. Well, it usually follows one after the other, really, as a way of sort of flushing out the migrants from the system, and then the process repeats all over again. And there was an interesting study that was done by Elizabeth Franz from OSF, looking at this sort of cycle of regularization as an avoidance of making structural changes to the migration system. So I guess I just wanted to contest that assumption. You know, I think in the Arab states or perhaps other rigid migration systems, I think it's a little bit more nuanced.
Thank you. So then we have Yolanda and Stephanie. So Yolanda first.
Michele, I heard you talk about US labor and firewalls in the context of the EU, but I was just wondering if there was something in the context of the US. And one of the issues when we talk about tension, and in the panel you were discussing the detention of children. I guess the other tension though is if, not that I'm saying they should be detained because I do not think they should be, but the other context is then if they're not detained, then where do they go? And the problem obviously in the US is that either they're stripped from their parents or they're deported back unless they go into some kind of either foster care. So I'm just wondering about thoughts about what are the thoughts to the answer to that question. The other issue that I was thinking about is hospitals in the US, the issue of not state actors, but non-state actors, because many times it's the hospitals themselves that have actually contracted have actually rented out like helicopters or airplanes to actually transfer those who have been injured, who are undocumented, to their country of origin. And so how would that change if there was a firewall policy put in place? And then the other issue is how does this go hand in hand, I think, with the long-term goals? Because I think when we think about firewalls, I think of them maybe as a temporary solution, but maybe not as a permanent solution, as things that are needed in a change of rhetoric or public attitudes, for instance, because, you know, migrant farm workers, 85% of them in the United States or probably more are irregular migrants. They seem to be the most protested as far as giving them any rights or giving them the ability to stay. But every time comprehensive immigration reform comes into place, there is a special place for them because we need them, right? So the change in the knowledge that they are actually necessary, we don't have enough of the low other skill or farm worker skill visas to be able to have them come in. They're always temporary, they can never regularize, such as the business workers. And so that is something, as well as the ability to regularize as an irregular migrant who e-weed, right, is not allowed, but someone who visa overstayed, who has family can. So those kinds of things, in my opinion, would be easy to change, but politically it may not be. So those are some of my thoughts.
Thanks, Yolanda. Stephanie?
Yeah, Michele, I was wondering if you could talk about when you mentioned that all of these things have to be balanced by policy objectives and wanting to increase one and not have it counteract another one. But can you talk about how you have thought or what research you've done on states' interest in deterrence and not wanting, and is there a correlation between increasing protection and increasing irregular arrivals? And just how you're thinking about states, I think, often interest in deterring irregular migrants.
Thanks. So maybe we reverse the order this time, if that's all right, and begin with Michele, if that's okay.
Okay, thanks. I think in terms of Yolanda's question, I'm just looking with Sophia's, in terms of the issues that you referred to with children. So for example, detention of children, where do they go? Actually, we're looking at trying to look at community-based non-custodial solutions. So basically allowing people to remain where they usually are living to begin with, like remain living in their community where they get assistance from a social work, who then also can help them look at different legal, like not legalization, but legal aid, basically, to look at their case. It was very interesting. I mentioned the city initiative on irregular migrants. So there's almost 50 cities that are involved in that. And some years ago, we visited as the initiative, an organization that the city of Utrecht supports that works with unaccompanied young people. And they said by just this process of having this legal aid and this accompaniment, they were able to find solutions basically for almost 90% of the young people that had been given some kind of an answer from the system, but who hadn't had their cases explored properly. And by solutions, they don't mean 90% regularized. So they do mean majorities had found probably some way to stay in the Netherlands, but then some of them also did have a solution for them, which meant returning to their country of origin, but they were supported in the process. So I think the whole issue of moving people out of closed jail-like detention systems into community-based accompaniment, social work kind of settings is trying to accompany them on their own situation and not keep them in this jail-like, which is basically the enforcement. And I think what's interesting with moving them into those systems, moving away from closed detention to these other community-based systems, is that there's a number of pilot projects, not only in Europe, but in countries around the world, where civil society, researchers, and governments actually kind of work together to develop them. So there's a lot of evidence on the ground of this. But Yolanda, you had also talked about kind of how do we also then change the public attitude, change the rhetoric, advocate for more regular pathways, which might be a little bit more difficult to advocate for politically. I mean, this is actually at the heart of that Global Compact on Migration. It's called actually Global Compact on Safe, Orderly, and Regular Migration because the states who signed up for it want to have migration be regular. And yet when they came down to putting some words in their progress declaration, the whole sections on regular pathways were there, but they're not really well developed. And we also see that on the EU level. And this also links to, I think, Stephanie's point about deterrence. So the EU proposed its own pact on asylum and migration in September 2020, 2 years after the 2/3, 18 out of 27 EU member states adopted the Global Compact. So the EU Pact on Migration and Asylum is kind of like the EU's response to the Global Compact on Migration. And if you look at what's proposed in the EU Pact on Migration and Asylum, a large part of it is enforcement oriented. So I think it's either 5 or 6 legislative proposals and then 4 kind of policy recommendations. The legislative proposals are very highly concentrated on border management. But in one of them, it would actually increase detention of children, which is against Objective 13 of the Global Compact, which is basically where states say they want to work to end detention of children. So the EU's response, like the EU has had a common asylum and migration policy since 1999 with the Tampere Council conclusions. And fighting irregular migration, or at the time in 1999, was probably combating illegal migration, which was the terminology. But that was one of the main areas. And so this pact that was then proposed in 2020 is kind of just a newer iteration of this, where we see the Frontex as the EU agency's budget has very significantly increased in recent years, where we also see that people who provide humanitarian assistance, both kind of rescuing people from the Mediterranean, helping people who are crossing mountainous regions into the EU or within the EU, transporting them in their car to prevent hypothermia, giving people shelter because they're homeless. All of that basic humanitarian assistance to undocumented migrants is being criminalized. So we see this coming up. Actually, the Greens in the European Parliament will release a report next month where they looked at a period from January until March, January 2021 until March of this year. And they found almost 90 cases of people, and that's just media reporting. It's most likely an undercount, but basically people who are criminalized. So it's just yet another indication that the predominant approach is usually security enforcement. Labor migration and regular pathways are still part of the EU's package on the pact. And there was the talent and skills partnership proposal that was launched recently, but it's still mainly kind of focused on people who are highly skilled. It's not really looking at the breadth of the labor needs on migration. So I think that's where we kind of still see a lot of these dilemmas.
Yes, thank you. I would like to start by responding to Sophia. I think these are very relevant and interesting comments because they raise two issues. The first one is the issue of context, right? So the idea of regularization is that by becoming regularized, you will have a less vulnerable position because you have rights, legally enforceable rights. You can go to court and claim them. And your position with regards to the access to courts and to these rights is also one that is permanent, is not dependent on discretionary application and so on. Now, if we're talking about many of the Arab states where a lot of labor migration is going to, domestic migration into the Gulf states and so on, this might not be the case. Regularization might not bring with it the benefits because these women might not have access to other job opportunities. If they're regularized, they might be still stuck in domestic labor. They might not have access to better protection if they suffer domestic violence because the laws are not such that offer this protection even to those who are citizens. So of course, this is all highly dependent on context, and in a way, it will only be meaningful. Also, firewalls, regularization, this is all meaningful only in a context where there are established legal protections. But in that context, I think it is key because regularization offers precisely a path towards less discretion, less vulnerability, and eventually also to permanent residence and citizenship status in a democratic context of liberal rights. The other issue I think that comes up from your comments, which is quite interesting, is this overlap between regularizing status and regularizing the actual employment relationship, right? It's just related, but not the same. And I think Martin can speak more to it, but I think what he wanted to point out, or what Martin has already also pointed out and comes out of your comments as well, is that the employment relationship might be one where these questions take on a specific dynamic that is different from healthcare, education, and so on. Because here, the state has an interest not only in controlling, enforcing legal migration provisions, but also in not having irregular work where there are no taxes, where people don't, and so on. And in your case, what you show is from the migrants' perspective, this might be sometimes beneficial. So there might be not an interest in regularizing the work relationship. Now this, in a context where you have a labor market with a lot of options, I think regularization would still be interesting because the person is no longer necessarily attached to that exploitative work relationship, but where you don't have options. So yeah, I think I don't have an answer. I really just sort of highlighting what I think are really important questions, your comments.
Thanks. And so final word to Martin. Can I just throw in another question, Martin, if that's all right? Is it amongst all your dilemmas, is there some kind of rank order? Because you kind of throw out a lot of dilemmas. And so within your field of dilemmas, do some dilemmas have more significance than others? Could some dilemmas help resolve others? But also more broadly, when you think about your project, is there some necessity also to justify the status of these dilemmas compared to many other very complex and potentially resolvable dilemmas in global politics? So I mean, that's not and could you answer that in about one minute, please, with the other ones? Thanks.
Yeah, thanks. No, I mean, what's been really interesting is we do spend quite a lot of time thinking and also writing about what exactly do we mean by dilemma, because, so we discuss dilemmas, but of course, actually, as we'll see in the upcoming debate that we'll publish soon on protection here versus protection there, where the question was, we kind of posed the idea there's a dilemma between protecting refugees in rich countries versus protecting them in first countries of asylum, which are typically low-income countries, where I think a couple of people responding suggested, well, they don't agree with the dilemma. So I think there is an important question of, is there really a dilemma? What is its nature? But we do think that now, does immigration raise dilemmas? I think in public policy, you always have dilemmas, but I think we're not just talking about competing policy objectives in a way. I mean, there's a literature, as many of you will know, on also managing value conflicts in public policy. And there's different ways of doing that, and firewalls is one way of doing it. We have education objectives, we have economic objectives, we have trade objectives. Sometimes they're compatible, sometimes they're not compatible. And actually, one response is to fragment the governance of it. So we have different ministries who are responsible for different things, and they clash. We know that they clash, but that's the way it plays out. So I mean, I don't have a good answer to whether there are any more acute dilemmas in this field. Obviously, we work on migration and integration, but what we spend a lot of time is, what's the nature of the dilemma? Is it a dilemma? And at what level does the dilemma operate? And we do have an interest in not, as I said before, in not just talking about political feasibility. So it's not just about, even though I personally believe political feasibility is really, really important to think about, but it is essentially about two competing moral goals that, in a way, that will not go away. Even when you try to address the tension, there will still be some sort of moral price you pay. Very briefly, just I think basically in response to Sophia's point, which I think is really important. I mean, I think Julia has put it very elegantly. I think context is really, really important, and it also matters not only. So Gulf is obviously a particular place, not only because of the kind of non-democratic setting, but also because there's not that many competing domestic workers. So the point I'm trying to make is, when we think about rights, I think in my view, a primary consideration should be the interests of the rights holders. How can we help? But there's a second consideration, which is the impact, the externalities of rights. So rights is about protecting people, but also so among citizens, so we are not letting ourselves do certain things, engage in irregular employment contracts that might make us more competitive, for example. That might mean we get a job over somebody else. So I think it does depend on the context, and in that context, it's really important. Again, an obvious point, not to forget that legal status might not be the primary determinant of vulnerability. And I think sometimes it is assumed that what's caused vulnerability is legal, but as you rightly say, we know from the extensive research on temporary labor migration programs that the tying of workers to employers can have very adverse consequences. And indeed, in some contexts, being irregular might mean you have more flexibility. So that means that the effects of legalization can be quite heterogeneous across countries. And in some countries, the answer might not be legalization at all, because no matter whether you have regular or irregular status, you're exploited in the same way, for example, because there is no labor inspectorate. In general, working conditions are not enforced. So really the answer should be with reform to the broader structures for everybody, rather than with this very specific change in the legal status of migrants. Thank you.
Thanks, Martin. So I think we'll wrap up this session. There's quite a lot of people in the room fanning themselves. I think people need to get out and get some air. It's getting quite warm here. But I'd like to thank everybody who joined us online. So thank you for being with us this afternoon. And everybody in the room, and in particular our three speakers, Michele LeVoy, and thanks for her patience in hanging on while we were a bit delayed. Sorry about that. Julia and Martin. So thank you very much.
Thank you, everyone. Goodbye.